ever received a letter from the Board of Nursing, your heart is probably racing right now. I get it, but here's what you need to know immediately. That letter is not a guilty verdict. It's the beginning of an administrative process, and what you do in the next 48 hours will either protect your license or put it at unnecessary risk. I'm Cambria Nuosu, and I have a doctorate in nursing practice in healthcare administration. I work very closely in healthcare policy. I'm a legal nurse consultant, and I do work in law. So I want to help nurses and other healthcare professionals navigate tough situations like this. So today I'm walking you through exactly what to do and what never to do when the board contacts you. Let's get into it. Here are the main types you might receive. A complaint notification means someone, a patient, family member, coworker, or your employer filed an allegation against you. This doesn't mean it's valid. It just means the board is required to investigate. A request for a written statement means that they want your version of what happened. So this is where most nurses accidentally hurt themselves, and we'll talk about why in a minute. A records or subpoena request means they're gathering documentation, charts, emails, incident reports. They're building their file. An invitation to an informal conference means they want to meet you before deciding on next steps. So this sounds casual. It's not. Every one of these letters include a deadline. So missing that deadline can be interpreted as non-cooperation, which escalate things unnecessarily. So step 1, read the letter carefully. Identify what type it is, what they're asking for, and when you need to respond. Then, and this is very critical, stop. Do not reply yet. So when panic sets in, nurses do 3 things that make their situation worse. 1, they over-explain. They write paragraphs about their work ethic, their patient care philosophy, their entire nursing history. Nobody asked for that. 2, they apologize for things that aren't even being investigated. So I've seen nurses say, "I'm sorry if I made anyone uncomfortable," when the complaint had nothing to do with that. So now you've just introduced a new issue. 3, they provide unnecessary details. So trying to be helpful, they mention other incidents, other patients, other staff members. Every extra detail is something the board can follow up on. So here's an example. A nurse gets a letter about a medication error. Instead of addressing that one incident, she writes about how short-staffed they were, how the charge nurse was unhelpful, how she was tired from working doubles. So now the board is wondering about her judgment, her workplace relationships, and whether fatigue is a pattern. So your instinct is to defend yourself. I understand that. But right now, your job is to gather information and get representation. That's it. So this is not optional. If the board is contacting you, you need an attorney who specializes in board of nursing and administrative law cases, not a medical malpractice attorney. They handle lawsuits, not licensed defense, not a criminal defense attorney. This isn't a criminal case. Not your family friend who does real estate law. They mean well, but they don't know this world. Administrative law is its own specialty. An attorney who regularly works with your state's Board of Nursing knows how investigators think and what they prioritize, which evidence actually matters in these cases, when a written statement helps you and when it can destroy you, and then what outcomes are realistic based on past cases with similar facts. So here's the things that nurses worry about. Won't hiring a lawyer make me look guilty? No, It makes you look informed. Your employer has attorneys. The board has attorneys. You deserve the same protection. Period. Written statement becomes permanent evidence. Once you submit it, you cannot take it back. You cannot revise it. You cannot say, that's not what I meant. Nurses, good, caring, competent nurses, sabotage themselves in writing because they use apologetic or emotional language that sounds like an admission. Add context that wasn't asked for and accidentally creates new questions. Try to explain their thought process in a way that sounds defensive. Use casual phrasing that gets misinterpreted in a formal investigation. So let me give you a real scenario. A nurse was asked to explain why she didn't document a patient fall immediately. In her written statement, she said, I was overwhelmed and forgot to chart it right away, but I did tell the charge nurse verbally. Sound reasonable, right? But now the board sees admission of being overwhelmed, admission of a documentation failure, and a verbal report with no proof. That statement turned a minor documentation issue into a competency question. Your attorney will help you craft a factual, concise response that addresses exactly what's being asked. Nothing more, nothing less. That's not hiding the truth. It's answering the question appropriately. Talk to your attorney before you send anything. Nurses think they're helping themselves by being cooperative and transparent. Sometimes you are, but sometimes you're accidentally providing evidence that wasn't even relevant to the original complaint. So here's what I've seen nurses do. They've been sending screenshots of group text to prove they reported something, but the screenshots also show them venting about management. Forward internal emails that contain other nurses' names or other protected health information. Print chart copies without proper redaction, exposing other patients' data. Add clarifying notes after the fact, not realizing that every edit is time stamped in the EHR system. And that last one is very critical. Hospitals, EHR systems, and the board can all see metadata. If you go back into a chart and add information after an investigation starts, that looks like you're altering records, even if your intention was innocent. So here's the rule. Preserve everything. Alter nothing. Send nothing without guidance. Save your personal notes. Keep copies of your schedule. Screenshot important texts from supervisors or charge nurses before they disappear. But do not modify, delete, or submit anything on your own. This one is hard because when you're scared, you want support. But here's the reality. Do not tell your coworkers, even your closest work friends. People talk. Stories get exaggerated. What you said in confidence gets repeated in the break room, and suddenly 5 different versions are floating around. Do not vent to your manager. Your manager's job is to protect the facility, not you. Anything you say can end up in their report to HR or their statement to the board. Do not talk to HR without your attorney present. HR is not your advocate. They represent the hospital. If they're asking you questions, they're gathering information for the organization's protection. I know a nurse who told a coworker who was being investigated for a charting issue. That coworker mentioned it to another nurse who mentioned it to a manager who then launched an internal audit of all of her charts. So what started as one isolated complaint turned into a facility-wide review because she didn't stay quiet. You're not being paranoid, you're being strategic. Once your case is resolved, you can talk about it if you want. But right now, silence protects you. Most nurses imagine the worst case scenario, losing their license forever, but that's not how most of these cases end. Boards have a range of responses depending on the severity and context of the complaint. Dismissal happens when the complaint is unfounded or there's no evidence of wrongdoing. This is more common than you think. A letter of concern is issued for minor issues, maybe a documentation error or a procedural violation that didn't harm anyone. It goes in your file but doesn't restrict your license. A consent order might require you to take additional education, attend a remediation program, or undergo monitoring for a specific period. It's serious, but it's not a suspension. Probation means you can still work, but with conditions. The board might require supervision, regular reports, or practice restrictions. Suspension is temporary removal of your license, usually for a set period or until certain conditions are met. Revocation is permanent loss of your license. This is rare and typically involves intentional harm, drug diversion, or severe impairment that can't be remediated. The board's job is public protection, not punishment. They're looking at risk. If you made an honest mistake, took responsibility appropriately, and there's no pattern of behavior, that's very different from intentional misconduct or ongoing impairment. Understanding this range helps you breathe again. Not every investigation ends in disaster. Whether your case gets dismissed or results in a consent order, you should walk away with stronger habits that protect you in the future. So here's what that looks like. Strengthen your documentation. Chart accurately, timely, and completely. If it wasn't documented legally, it didn't happen. Report unsafe assignments immediately. If you're being asked to take on more patients than you can safely manage, document that refusal and report it up the chain. Don't just complain, create a paper trail. Stop taking verbal orders without confirmation. Get it in writing or chart it immediately with the provider's name and time. Never text health protected information, or I should say protected health information. I don't care how convenient it is, use secure hospital messaging systems only. Carry your own nursing liability insurance. It is inexpensive. Usually it ranges from $100 to $200 a year, and it gives you access to legal support independent of your employer. Save important workplace communication in real time. If a manager tells you to do something questionable, email them to confirm. Per our conversation, you're asking me to do what? Keep that email. You can't eliminate risk in healthcare, but you can stop being an easy target. So in closing, a board of nursing letter is one of the most stressful things a nurse can receive. I'm not going to sugarcoat that, but it is not the end of your career. The difference between a nurse who protects their license and one who loses it often comes down to how they respond in the first 48 hours. So let me leave you with this. Read the letter carefully. Do not respond emotionally. Get an attorney who specializes in board cases. Do not submit anything in writing without counsel. Preserve all documentation. Stop talking about it at work. And prepare yourself for a process, not a verdict. Your license is worth protecting. Treat it that way. If this video helped you, please share with another nurse who might need it. And if you're currently going through this, take a deep breath. You're going to get through it. Thanks for watching.